Good morning once again, class. I remain Dr. Bello Mohammed Magaji, Associate Professor of Law, School of Law, American University of Nigeria, here in Yola, Adamawa State. We are concluding the series of discussion on the law of contracts, particularly the formation of a contract, having looked at the elements that make up a contract. One of the elements we shall be looking at it conclusively today, that is legality of the contract as an element of a contract. This presupposes that the agreement, the entire agreement, or the whole agreement of the contract must be legal, something that is seen as lawful in the eyes of the law. Now, the legality of a contract, as I have said, refers to whether the subject matter or purpose of the contract is lawful and does not violate in any way any law or is against public policy. In Nigeria, the legality of a contract is determined by both judicial decisions and statutory provisions. What we mean is that there are certain judicial pronouncements that go to support the fact that an agreement or a contract must be seen as lawful in the eye of the law before it becomes enforceable. Now, there are a lot of plethora of cases where the courts have continuously states that the formation of a contract must be lawful. The case of Egbe against Adefarasi, reported in 1987, where the Supreme Court held that a contract is illegal if its purpose or object is illegal or contrary to public policy. The court further stated that contracts that involve fraud, immorality, or are against public interest are considered illegal and unenforceable. Let us look at the categories once again as stated by the Supreme Court. Contracts that involve fraud, anything that is fraudulent, the courts will not enforce it. Anything that is immoral, there are so many categories under this, the courts will not enforce such. Or anything that is against the public interest, any contract that is against the public interest, i.e. maybe corrupt tendencies or against the public service and all that stuff, the contracts will not be enforceable, i.e. they are against public interest, so illegal and unlawful as far as the law or the courts are concerned. And these are all, as I have mentioned, considered illegal and unenforceable as far as the judicial pronouncements are concerned. Now, what of the statutory authorities that support the fact that contracts must be legal before they are enforced? The Contract Act, Section 3, provides that a contract is void if it is expressly or impliedly prohibited by any law enforced in Nigeria. There are so many laws that prohibit certain categories of contracts. For instance, there are laws that prohibit trafficking in human beings. There are laws that prohibit dealing in drugs. There are laws that prohibit corruption. There are laws that prohibit acts which are inimical to the economy of the country. These are all unenforceable and illegal contracts as far as the courts are concerned. Now, also, the Criminal Code Act of Nigeria criminalizes certain activities such as fraud, bribery, and corruption, and rape, so many categories of actions or activities which the penal law or the criminal code prohibits. These are criminal in themselves, and accordingly they are illegal as far as the law of contract is concerned. We shall look at this in greater detail when we come to the topic of legality as a topic itself in the law of contract, so that we will now look at the various categories of criminal offenses, criminal activities, criminal prohibitions that the law prohibits, and the authorities for such prohibition. Thank you very much and have a good day.